Thank you very much, Ritika, for this generous introduction. And I'm really looking forward excitedly to be able to meet you, talk to you, although it's virtually. Yet it's a pleasure to talk to my young friends. Let me start off by giving a brief feel of a flavor of both these laws and how do they interface with each other. Competition law and consumer law are essentially intertwined and they are two sides of the same coin. Both aim at protecting the interest of consumers from various angles. As everyone in trade and industry is also a consumer of goods and services, in the end serves the end consumer, and I'll explain the difference in a moment. This subject is of tremendous relevance to everyone, as I shall explain towards the later half of my talk. The competition law is basically to create conditions which are conducive for the consumer welfare, and the consumer laws, they are essentially designed to serve the main transactions. Consumer Protection Act is concerned with the nature of consumer transactions, trying to improve market conditions for effective exercise of consumer choice. Competition Act investigates all actions that may hinder competition and reduce consumers' welfare and choice in the market. Competition law has two aspects, one for the companies and the other for consumers. For companies, it includes compliance, the law which aims to create a level playing field in the market, create conditions conducive for economic democracy, as enshrined in the preamble of the Constitution of India. The main provisions of the Constitution is also the directive principles and also in the preamble of the Competition Act. If you look at the preamble of the Constitution, we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens, and that is something which is important, that justice, social, economic, and political. So, economic justice would imply equal opportunities for all and also economic democracy. Competition law is helpful for economic democracy. In competition law, if you look at the preamble, and I would strongly suggest that you must read it very carefully. The preamble says it's an act to provide, keeping in view the economic development of the country, for the establishment of a commission to prevent practices having adverse effect on competition, to promote and sustain competition in markets, and here it's important to protect the interest of consumers and to ensure freedom of trade carried on by other participants in markets in India and for matters connected therewith or incidental thereto. So it is very heavily biased for protecting the interest of consumers and also for promoting economic democracy, that for all the participants in the markets there should be freedom of trade and equal opportunities. So if we look at the competition law, it is a law that promotes and seeks to maintain market competition by regulating anti-competitive conduct by markets, by companies. It is also described, and this is important, it is described as a law which makes the market work for consumers. And this is something which I have been mentioning everywhere during my various speeches when I was chairman CCI, and at that time there was not much of awareness about competition and competition law. In fact, people used to ask me, what do you do? Do you conduct competitive examinations? But I used to explain that this is a law which makes the market work for consumers. And it has three pillars: to prevent practices having adverse effect on competition, to promote and sustain competition in markets. Second pillar is to protect the interest of consumers. This comes up again and again. Third is to ensure freedom of trade carried on by other participants in markets in India. And the last one is of special interest to MSMEs, freedom of trade by various participants in the markets in India, and also creating conditions which are conducive for their free and unhindered functioning. From the preamble, it's clear that we promote competition to level commercial playing field and to support policies and frameworks that protect and empower consumers. Competition stimulates innovation, productivity, and competitiveness, contributing to an effective business environment. This generates economic growth and employment. It creates possibilities for small and medium sized enterprises, removes barriers that protect entrenched elites, and reduces opportunities for corruption. Competition increases a company's attractiveness as a business location. It would be located where it can bring products and services to the consumers at most competitive prices and the best quality, triggering national and foreign investments. It also delivers benefits for consumers through lower prices, improved services, and greater choice. In this sense, competition generates total consumer welfare. Consumer protection benefits all consumers by ensuring that they have right of access to products, provide adequate information to enable them to make informed choices. And that is something which is important, and I would suggest that please keep two words in your mind as whenever you talk of the competition law. One is choice. So it protects choice of consumers. Consumers should be the king. Consumers should have freedom of choice, and it should be informed choice. The consumers should be informed uh, various aspects of the product and the services. So to make them available informed choices according to individual wishes and needs, and effective redress in effect empowering them. So if there are any grievances, they should be redressed. Empowered consumers who know their rights and enforce them are subject to fewer abuses. This directly improves their welfare. It also contributes to creating a level playing field for businesses which have to apply a common set of standards supporting competition. When we talk of the competition law, please remember this phrase, appreciable adverse effect on competition. This is extremely important and being used repeatedly in various sections of the competition law. Similarly, under section 19(4), among other factors, dominant position is also determined by the dependence of consumers on the enterprise and entry barriers, including barriers such as regulatory barriers, financial risk, high capital cost of entry, marketing entry barriers, technical barriers, economics of scale, high cost of substitutable goods or services for consumers. And why I elaborated these factors, that if the barriers exist in the market, the new entrants would be discouraged, they would be hindered, and we want to encourage new entrants not only for economic democracy but encouraging in competition in the market by getting new entrants and new participants would be helpful in reducing prices by competition and providing improved products and services, because they would be competing for the custom of the consumers. Under section 19(6) and 19(7), relevant geographical market and product market are determined by many factors. One of the major factors among them, as listed in the competition law, is consumer preference. And again, something which is important for you to remember, because consumer preferences, consumer interest is repeatedly, it figures in the competition law. If we look at the judgment of the Honorable Supreme Court of India, it's the most celebrated judgment. This was uh, laid down by the Honorable Supreme Court, Competition Commission of India versus Steel Authority of India. And I would strongly urge on you that do kindly Google and see this judgment, because this is like Magna Carta of competition law. In this judgment, the Honorable Supreme Court again laid great emphasis on consumer interest, and I'll quickly read out the relevant portion. In this, the court held that it is not obligatory on the part of CCI to issue notice or grant hearing to the opposite parties prior to the issuance of direction to the Director General to commence investigation on a complaint under Section 26(1) of the Act. Still, the Commission may hold preliminary conference to seek assistance with the concerned parties before framing a prima facie opinion. This is something which is just a precursor. In fact, I was the chairman when we took our appellate authority to the Supreme Court and won our case against them. And the Supreme Court laid down, and this is what I wanted to bring to your notice. The principal object of the Act in terms of the preamble, statement of objects and reasons are to eliminate practices having adverse effects on competition, to promote and sustain competition in the market, and then it is important, this line, to protect the interest of the consumers and to ensure freedom of trade, carried on by the participants in the market in view of the economic developments of the country. In other words, the Act provides and requires not only the protection of trade, but also protection of consumer interests. So protection of consumer interest is extremely important. And when we talk of the competition laws, it talks about protecting competition, protecting and promoting competition for the benefit of consumers and promoting the consumers' welfare. Using competition as a tool brings following benefits for the consumers. It is a means of lowering prices and improving quality, which is obvious in competition. The participants would be offering better products, lower priced products. Consumer prices get lowered because with a better degree of competition, productivity of the industries and innovation increases. As the productivity increases, that's to the dynamic efficiency in the economic value chain. Not only the consumer prices get lowered, but also employment increases. It leads to consumer empowerment because of the promotion of factors like higher degree of consumer protection, freedom of individual choice, and abhorrence of concentration of power and decentralized economic efficiency. It also aims for open market so that the situation of shortages can be avoided, and therefore allocative efficiency also gets increased. By achieving all these objectives, growth and development get accelerated and political and economic democracy gets preserved. It also produces better and wider choices. Competition law also provides for compensation. And here I would like to bring to your notice, and this is important for you to know, Section 53N by the Competition Appellate Tribunal from any enterprise for loss or damage shown to have suffered as a result of contravention by the enterprise. And Section 53N provides that anybody who suffers injury because of lack of competition or because of anti-competitive practices, they can file a case in the Competition Appellate Tribunal and seek compensation, retribution for the injury caused.